Okay, so looks like we'll go ahead and get started here. It's just about 12 noon, high noon here in the Bethesda Conference Center. Hello everyone, I'm Don Collins. I'm with the Archive Branch at the National Centers for Environmental Information, and this session here late in the afternoon on what is the Friday for the week of ESIP is License Up, what license works for you and your downstream repositories. And I really appreciate you all being here after the little snack and before lunch, so keep lunch in mind. I'm really excited to have this session, and this is just the review of the abstract that we put out here to promote this session. But this really grew out of some discussions that we were having and some new situations we were encountering at NCEI, where we were starting to see different kinds of licenses, particularly Creative Commons licenses, attached to data sets that were coming to us. And every time there would be some kind of new license, we would have to understand, well, what does this license mean to us as a facility to redistribute these data? Can we do it without violating the license? Do we need to go back to the data provider to have them change their mind about their license? Or what are the ramifications of all that? And so it's also sort of expanded into issues about software and interaction, working with federal staff, working with contract staff, working with cooperative institute staff, and these combined virtual organizations and collaborative teams. And what are the intellectual property rights management aspects of these teams, and what do we do about all these different situations? So I thought it might be helpful to have some discussion with people who actually know about those legal characteristics of these agreements, and instead of me asking different lawyers at different places, what should we do about this? But before we go on, and before I introduce our guest speakers today, I want to do a little quick pop quiz here for the participants here in the room. So just to get a feel for who our audience is here today. So of the folks that are out here in the room today, how many of you have actually collected data and then sent it off to some data repository? One or two, three, a few folks. So, okay, yep, good, okay. Now, how many of you have worked with data and applied some kind of a license to the data that you work with? Any of you? No? Oh, few? Yeah, few of you, okay. How about software folks? I don't know how many software people there are in here, but you've written software and okay, so there's some software people doing different parts of software. Okay, here's the last one. So how many of you are lawyers, or at least you talk to someone who is legal counsel about the licenses that you might have applied to your software or your data? Okay, not so many hands there, okay. Kind of what I suspected, but that's quite all right. I'm gonna make sure I'm sharing. Shelley, can you tell me, am I up to date on my screen there? Okay, so this is projecting out to whoever might be out online. Okay, so with that pop quiz behind us, I'd like to introduce our presenters. I'm not gonna read all this, but Henry Wixson here is the Chief Counsel at the National Institutes of Standards and Technology here in Gaithersburg. And I'm excited to hear, you can all read his bio here. He's been very active in a lot of different groups, and I'm not gonna try to characterize all that, but I'm really excited to hear the presentation from Henry. And then Dr. Bob Hanisch is here as well from NIST. And he's been a senior scientist at the Space Telescope and Science Institute in Baltimore, and also worked on a lot of the issues that are near and dear to all of our hearts here at ESIP. So with that, I'm going to hand it over to to Henry and let you get started. You can stand here at the screen, might be easier. Let me set this down. And let's see, stop presenting that. Let's see, this one, this. Slideshow. There you go. It's all yours.
Great.
Take it away.
Don, thanks so much. It's a pleasure to be here this afternoon and to talk about a subject that's near and dear to the heart of every one of us lawyers here in the audience today. But as Don said, I'm with NIST, the National Institute of Standards and Technology, sister bureau of NOAA within the Department of Commerce. My background, I'm a patent attorney by training, and I was in private practice for a couple of decades before joining NIST in 2009, and focused on intellectual property law pretty much my entire career. And one of the interesting things about working at NIST and getting involved in the projects that our clients, our NIST clients, get involved in is that really was the bulk of my introduction to open source, and open source licensing came after I joined the government, because when I was in private practice, I was working primarily for companies, small to mid-sized biotech companies predominantly, and they were not doing open source work. They were doing regular licensing. So I have a lot of experience in regular licensing. And so it's important as we think about open source licensing to sort of get a sense of what we're talking about here and what licensing is in some respects. And I'm going to start by talking about open source software and open source software licensing. Spend quite a bit of time on that. Hit some of the highlights of some of the various licenses that are out there. I'm not going to try and go through everything provision by provision. What I hope to do essentially today is maybe just help to improve your ability to be an informed consumer of legal services if you are trying to make a decision about what I should do or how we should set something up or what kind of license to use, and you go to your legal counsel for your agency or whatever. Are we all feds in here, or feds and contractors, or what are we? We're just here in North Bethesda and okay, great. Well, whatever your bag, then we're going to try and make you an informed consumer. And so those couple of, just to start off, so after I talk about open source and open source licensing, I want to spend a little bit of time on rights and data, because this audience is particularly concerned with data. And as a separate matter in government contracts in particular, data are addressed separately under what are called the rights and data clause under the federal acquisition regulations, and most agencies, even if they're not using the FAR, they have their own version of it that they work under. So I'm going to talk about that as a little bit as well. So what is open source software? Open source software is licensed under a license conforming to the open source definition. We find the open source definition at the Open Source Institute. And if you go online and search Open Source Institute, which I would strongly recommend if you're trying to get familiar with this, they have a web page with a whole lot of information, a lot of resources for you, and they go through a lot of the information in many respects that I'll be talking about today. But they all perform the very important function of identifying those licenses that are out in the wild that satisfy the OSI's definition of open source license. So we typically see open source type licenses in community development projects where we're trying to encourage a whole bunch of people to make contributions. It's not always necessary to use an open source license in that context, but that's pretty much where we see it. So I have my own little quiz here inspired by Don. So what is it that makes an open source software license or open source software different than proprietary software? Anybody got a? Well, we'll just see what happens. So it's distributed under an open source license. That's the biggest difference. So the concept of licensing is that if you have a right to exclude somebody from doing something, if you own something. So if we use the analogy to your automobile, right? You own your automobile. If somebody takes your automobile without your permission, they've stolen it, and you have a right to try and fix that. But if you give them permission to take your car, even though you still own the car, they have the right to use it. And you've said, you may use my car and I will not sue you if you walk off with it. I won't for a stolen vehicle. I won't ask the state to put you in jail. So I give you permission to use my property. And that's basically what a license is. It's permission to use your property. And it doesn't mean in granting a license that you give up the property. You still have the property. But you've given permission to do it. And when you do that in the typical proprietary software system on a one-off basis, right? So each individual who wants to use your proprietary software, you say yes or no, you may use it, and here are the terms under which you may use it. And if you're selling it as part of your business model, you sell it for a price. In the open source software context, the difference, one of the things we want to avoid or try to minimize is that bilateral nature, the need to have an agreement with each individual person. So the open source approach is to have a license that applies to everybody, and that in fact applies without the need to have a written document. So that is one of the important things to keep in mind. And we'll talk a little bit later about what happens if there's a violation of an open source license. And the reason that it's important to keep in mind that we're not giving away the information itself, we're giving away a right to use it, is that if there's a violation of that license, whether it's a proprietary license or an open source license, it can result in, in consequences that could mean you can't use its software anymore because you violated the terms of the license, even if it's an open source license. So, is it in the public domain? No. And as I've just said, it's not, because if you violate the terms of your open source license, it could result in your not being allowed to use it and other consequences. So the concept of public domain is an important one because it's a word that we bandy around a lot when we're talking about things, and it's often misused in the context of open source licensing. So public domain means that there are no rights that attach to it at all. So you can use it without any restriction and without fear, if it's in the public domain, that somebody's going to say, oh, you can't do that anymore, you have to stop. If it's in the public domain, it's out there, and nobody in theory has the right to do anything with it. And so for those of you, I'll just say it now before I forget it, for those of you who are feds, right, in the context of generating stuff as a federal employee, there's a provision of the copyright statute that basically says that feds are not entitled to have copyright in works of the government. And very often you will see individuals and sometimes agencies and departments say, oh, this software that was written by our employees in the public domain. And that's not an accurate statement. It is the accurate statement, because I know you're all interested in this as I am, is that it's not subject to copyright in the United States. That's in fact what the statute says. And so the important difference is that the fact that it's not subject to copyright in the United States doesn't mean that it's not subject to copyright elsewhere. So any federal agency who has an employee who generates copyrightable work is in a position, if they wish, to register a copyright elsewhere. And many agencies do that. The other important thing to keep in mind about copyright for feds is that the fact that we feds, if we generate something, may not be able to, to have copyrights in it. If we acquire copyrightable subject matter by some means or other, and that gets us actually into the rights and data clause provision that I'll talk about later, but we, the government, can accept an assignment of copyrights, of a copyright from another entity who can himself or herself have a copyright. So in many instances, agencies will contract for work that is copyrightable in nature, and then that you can obligate the contractor to assign their copyright in that work to the government. And once the government has an assignment of copyright, then the government can enforce that just like any other party. So those are a couple of important things to keep in mind with respect to copyrights in feds. And we may have more questions about that. And then the final question of my little survey here: if I use open source software, will I avoid infringing others' IPR, others' intellectual property rights? And the answer to that is not necessarily. So it's not, the takeaway there is not necessarily, and you have to do some looking in order to figure that out. So one thing I want to emphasize in talking about this whole topic is that we'll see that there are differences in the different types of licenses that are out there. Some are more appropriate for particular endeavors than others, and so the takeaway here is you got to think about what you're trying to accomplish, what your mission is, in carrying out this particular project. And then you need to make, what are hopefully conscious and informed decisions about what license structure or approach is going to allow you to achieve that mission. So there's no one size fits all solution for these things. And you have to keep, in doing that, you look at the license terms and see what the obligations are that are imposed on someone who is involved and uses that license. So what can they modify it? Some open source licenses permit it, some don't. Can they distribute it or redistribute it? That's an important thing to understand with respect to the license that you use. Do you have to have an obligation with respect to attribution from different people and those kinds of things? So open source, the open source definition. These are some of the key requirements for an open source license as defined by OSI, the open source definition. It must be royalty free, so you can't impose a royalty obligation under an open source license. It must permit modifications to the source code and redistribution of it, and it must not require a license execution. That's that binary, one-off, everybody signs things that I was talking about. And so it's important to keep in mind in that context that just because you don't need to sign a license doesn't mean that you don't have terms and conditions to comply with. You do. And it doesn't also mean that what you're dealing with is in the public domain. So there are generally a couple of, we can categorize the licenses, the open source licenses that are out there a couple of ways, and one is whether they're permissive or not. And the permissive licenses include the BSD license. I think what was the BSD was Berkeley Software Distribution. That was a long, long time ago, but it's BSD. And then MIT, what does MIT stand for? And then the Apache license. Those are the permissive licenses. And so they require you to reproduce, if you take something under those licenses, you have to reproduce whatever the notices are in the license that you're under. And there's no requirement of the permissive license to make source code available. And then you have another category of licenses, the reciprocal licenses, or the what are sometimes called the copyleft licenses. And they have more obligations in them than the permissive ones. So again, you have to reproduce notices and the license itself. You could be required, or you're typically required, to make the source code available if you're operating under a copyleft license. And the stronger copyleft licenses, which would be the general public, the GNU general public license, and the lesser general public license. Under those, the license terms may attach to combined code and programs via linking as well, so they can reach out via linking to have their provisions imposed in that manner, which can be very dangerous if you don't know that it's happening. The weaker copyleft licenses, and I have a couple of them listed here, MPL, EPL, and the CPL, are usually limited to modifications to the copyleft code or files containing the copyleft code. So let's go on and look at a couple of individual licenses that are frequently seen in the open source context, and just a couple of highlights from these different forms of licenses. Many of these licenses have gone through various iterations. So GPL version 2 is just what it sounds like. It's version 2. They are updated on a regular basis. And you'll see with respect to some of these licenses, people still citing to and using older versions of them. So you need to keep that in mind. And the other thing to keep in mind with respect to versions is that when you are entering into a license where you're using a particular version, it's important to understand whether or not you're going to stick with that version irrespective of updates to it, or whether you're going to have a license that says this version or any successor to it. Because as that's important, because if there's an important criterion or requirement in your version that gets changed later on, that was important to you in making that informed decision to pick this thing, and you allow it to be changed, and you could defeat your own objective. So it's just something to keep in mind. So there's a liberty or death clause in the GPL version 2. If you can't distribute applicable software under the terms, then you can't distribute it at all. So that's pretty restrictive. It's important to keep in mind. And so, for example, one of the things would be a requirement of binary only distribution. So you are only permitted under the license that we're talking about to distribute binary code. You can't distribute anything else, and so you can't distribute anything else. That's important to keep in mind. And there are copyleft provisions that we need to be aware of. Modifications to the source code must be licensed also under GPL version 2. This is the kind of thing that the commercial side, if you're working with commercial entities, they really get nervous about that. So there's this obligation, if you're going to make modifications, to use the GPL version 2 license with that. And derivative works must be licensed under that too. Now, the concept of a derivative works, is everybody familiar with that? That flows from the copyright. And so one of the rights, you have a litany of rights if you are a copyright owner, and that includes fundamentally the right to reproduce and to distribute. And one of the rights is to make derivative work. So a work that is based upon the copyrighted work is a derivative work, and that's one of the rights that you control if you're a copyright holder. Under this GPL version 2 license, we have the derivative work, again, like modifications to the source code. Derivative works must be licensed under the GPL version 2 license. So what is a derivative work? Well, I've just described it to you, but there could be questions raised about that. So you just need to be aware of that. GPL version 3 has a couple of notable provisions in it. The TiVo clause, coming from an older, I think it was a dispute that was involved or in the context of TiVo. Vendors must provide cryptographic keys necessary to modify software and enable execution of modified binaries. So the obligation to provide cryptographic keys under the GPL version 3 is an important thing, and that is intended to provide code signing techniques from being used, or prevent rather code signing techniques from being used to circumvent GPL terms. There's another important license term is a disclaimer of the DMCA anti-circumvention protections. And so the Digital Millennium Copyright Act, if you're on the internet, has certain protections against anti-circumvention of the copyright holder's rights through on the internet, I'll just say. And so under GPL v3, you have a disclaimer requirement there, and that might or might not be important. And then there's also patent license terms, non-discriminatory conveyance of necessary licenses and prohibitions against licensees filing suit for infringement related to the code. And we'll see that theme repeated in a couple of times. So one of the other things, and this particular one with the MPL version 2 license terms, some of these open source licenses play well with other licenses and some don't. And that's important just to recognize that some don't. MPL version 2 expressly permits dual licensing with the GPL license and the LGPL and AGPL. And then again, the license terminates under MPL version 2 if the licensee initiates a patent infringement suit. So if the licensee has patent rights and tries to sue, then that licensee's rights will terminate as a consequence of a patent infringement suit. Apache, which is a very, very frequently used code, Apache version 2, the licensor of the code must provide a perpetual worldwide non-exclusive no charge royalty-free irrevocable patent license to the licensee, if you're the licensor to the licensee. Now you read that, and that sounds actually incidentally very much like the government use license that we get under the Bayh-Dole Act when we're funding stuff. So it's just something to keep in mind if you're thinking about what to use and you happen to be a government agency. Well, if you use the Apache license, then you're going to have people that are granting every user in your community that kind of use right. So but it's non-exclusive right. And then automatic revocation, again, in the event that there's a patent infringement allegation. So BSD and MIT licenses, I mean, MIT is sort of the least restrictive, I guess I would say, of the licenses. There are no restrictions under either of these formats for modified or derivative works. You can distribute, you're allowed to distribute binary only versions. Some versions of these licenses require reproduction of the list of contributors to the original software. Most all of these licenses, incidentally, will require attribution. Some of them don't, but some of the versions, and I don't believe that MIT does, the basic one does, but some versions that are out there require that, and that can create compliance issues for you. Vanity licenses, here the concept is you make up your own license, and it's just be careful, because if you don't know what you're doing, you can have unintended consequences. And then the use of unlicensed code. And so if there's nothing attached to it, then you make this assumption that if there's nothing attached to it, there must not be any rights associated with it, and you could be wrong. There might be rights associated with it, and what you don't want to end up being is surprised, after you've incorporated something like that, and somebody says, "Wait a minute, I have rights in it," and then you have a big mess on your hands. You probably look to copyright law in that instance. So I have a couple of best practices here, and I've already alluded to some of this. Look at what you're doing, see if you can figure out what license applies, comply with the requirements of the licenses, and try and have a policy and procedure. For NIST, when we started to see more and more open source work about, I don't know, 4 or 5 years ago, we actually, in my little office, which has now, I think, 11, 12 people in it, we actually have an open source group in our office where we try to keep up with what's going on in open source. And that's a sort of a full-time job, to be honest with you. Because we have so many different employees coming to us and saying, "Oh, I want to do this, I want to do that. Somebody's giving me this, somebody's giving me that." They're all open source questions, and they're all different, and they're all different licenses, and it just takes a lot of time to stay on top of that. So if you're the agency you work at, or the company you work at, if you work for a company, should think about adopting a policy that will help to simplify your lives. And if you adopt it with your mission in mind, then it should help you to achieve your mission. And I think actually NASA is, if you look at NASA, they put out a whole lot of stuff, and they're pretty well organized over there. They're actually worth looking at as a model. So this is just some best practices. You want to be in a position to modify products that incorporates open source software, and in case you get surprised later on. So you want to put yourself in that position. So let's see here. How am I doing on time? Am I exceeding? I don't want to rob Bob of his opportunity to talk about more important things. Okay, I'm good. All right. Well, I'll keep going. And by the way, I can just drone on and on all. So yeah, yes, a question.
So, you're speaking to a non-lawyer audience, and so my question is so why is this important to me? And are we just concerned in the unlikely event that someone sues me, or are we actually talking about norms in society and how we engage and should be engaging in a scientific community? Do we use these licenses to actually set terms of use for our scientific activities?
Right. So I think that's a great question. Thank you very much for asking that. And as I said at the beginning, right, what we want to do if we're involved in big data projects, with most of you in the room are, we're trying to create a community to contribute to this overarching goal. And so one of the things that we can do in order to accomplish that is to present a licensing scheme, an open source licensing scheme in this context, that will encourage participation. So your goal is to encourage participation by others in your community, typically. And so because the open source community itself, the kinds of people out there in the wild who get involved in big data projects tend to be sort of open source oriented as a class. So they're going to come to most projects thinking this probably should be open source. But one of the points I'm trying to make is there's lots and lots of open source choices out there. So your challenge and opportunity is to select an open source model for your project that will allow you to accomplish whatever the goals are for that project, and encourage people to participate and reduce uncertainty about what the consequence of their participation would be. And particularly if you are trying to encourage commercial organizations to participate, right? Other companies and things like that. They are very much focused on predictability. They don't want to be surprised later on. They don't want to have their scientists, many of whom are open source oriented as well, contributing to a project that results in pain and suffering for the company. So they need to understand what the rules are, if you will, for contributions, for their contributions. And that's why you would then choose an open source model and say, this is how we're going to run this, so that people can understand that. Does that sort of address your question? Sort of. Okay, great. Yes, another question.
I have like two questions based on, I guess, your experience. The first one is, let's say you started off with an open source project and then later on your institution wants to keep it hidden. What happens to kind of what has already happened with the licensees, and kind of what's the legal situation in that particular situation?
Okay, so I mean, so when we're talking about some of the different kinds of licenses, so we have permissive and less permissive forms of licenses. So, for example, if you had started off with GPL, version 2, I think it was, or version 3. Now I don't remember which one it was, but anyway, we looked at a situation in which if we adopted the GPL model, it would apply to everything downstream and anything that got linked to it. And so if you were in that position and you'd started off with that model, you might find it very, very hard to pull back and say, oh, we're going to change the nature of this project now and basically not conform to the GPL license. So I mean, so
Yeah.
if you're the organization that's trying to run the thing, you need to be very aware of that, not end up in that position. And then one of the other themes we had in one of the slides was, you know, if I'm contributing to your project, and then for the purpose of your project, I may be happy to contribute and leave it there, but I might also want to do something with my stuff. Can I do that under the terms of the open source license that's being used, or have I dedicated, you know, essentially dedicated what I'm contributing to the public, and I can no longer use it for my own purposes. Mm-hmm. And that's where the commercial angle could come into play for a company. If a company were making a contribution and they might want to use that code for some other purpose, you want to have a license format that allows them to do that. And if you have a license format that doesn't allow them to do that and want to change, you might not be able to.
Okay. And then the second question I have is that, do you have any like stories of where there was an open source project that had some sort of license and then that license was violated, and then what exactly happened after that?
Yeah, so I have a couple of case sites. In fact, the slide that's on the screen right now. I didn't include, I have a bunch of slides about cases that had, you know, outcomes. I didn't bring them all today. But here's one of the things, right? So we said, you've got an open source license. That doesn't mean it's not in the public domain. It means there are requirements, there are conditions of use. And so the first thing that says here, right, is if the restriction, you know, on distribution, for example, can that create copyright infringement if there's a lack of compliance? Well, here in this case, Jacobson v. Katzer, if the restriction on distribution is a condition of the license and the condition is not met, if there's non-compliance with the license condition, if there's a breach of the license, then there is no license, right? That's the way this particular case played out. In the license said, in the event of a breach, your license terminates. And they breached, so their license terminated. The consequence of termination was they're no longer licensed. And then we go to the underlying right. What is the underlying right that supports the ability to say you can or cannot use it? It's the copyright, right? And so when there's no contract in place, then it's copyright infringement, and that's what happened in that case. So the consequence of non-compliance was termination and copyright infringement. So that's one of the things, the difference for the government, and one of the interesting things about our position here, under the copyright statute, 17 USC 105, is that if we enter into, as we do all the time, these kinds of contractual agreements, and with respect to something we own, there's a breach, and the contract terminates, there ain't no underlying copyright, right? That's what we said before. We, the government, for government works, we don't have copyright in the United States. And unless our smart counsel jumped through a lot of hoops and put us in a position to say, well, that may be, but we still have rights because, then you got nothing as an agency. So I just something to keep in mind. Yes, sir.
This first case that you cite is the general result of the decision there that once a condition of a license is violated, the license entirely is null and void, or can there be sort of backup provisions?
Right. So the next sentence, I mean, that's a very good question. So the next case sort of addressed that question, which is, well, okay, there's a restriction in the license. Is it really a condition, the breach of which would justifiably result in termination? And what the court said in the MDY Industries case is, Well, it's got to be a real condition. It can't just be any old restriction. It's got to be an actual real condition of the license in order for the consequence of failure to be considered to be a breach of the license. So the nature of the conditions imposed have to be looked at. And a lot of times it's the license itself in normal binary proprietary software type licenses. The license itself will tell you what breaches are going to be material. And a material breach is one that then justifies termination. Some breaches are material, some breaches are not material. And while it doesn't apply in our open source setting, most of the time, failure to pay, if you're obligated to pay money, like running royalties, so you're doing a patent license, and you fail to pay your royalty provision, that's not a material breach because it can easily be corrected. But if you're obligated under, there are other obligations that you have under that kind of license that are material. Anyway, you can identify those, the parties can do that. But what the court said with the nature of the open source licenses that we have is that they don't really get into that kind of detail, right? They're supposed to be short, they're supposed to be easy. One of the consequences of short is that you don't go into the kind of detail that us lawyers love, and then you put the court in a position of having to figure it out. That's what the court said in this case. These two cases is if you've got a real obligation and you breach it, then there's termination and you're an infringer. But if it's just a nice thing and it's not really that important and you fail, you breach that, it's not going to be a material breach and you're not going to be able to have the same consequence. So, yes. Maybe move on? Okay, let's move on. We're getting there. In the interest of time. I'm going to skip that. Okay, so this is we've said this a couple of times, and this is another theme, right? If you want to end up in distribution, which license is going to best fulfill your mission, right? If you're creating the project, if you have a contractor creating the project, if you're transferring rights to some other entity from the government, you're using existing open source projects, or you're supporting upstream projects. You just need to take all those things into consideration. Some different compliance tools, I just throw these up here. I'm not going to spend a lot of time on them. One of the issues with open source licenses is that you have compliance obligations, and how do you keep track of them? And they can get hard to keep track of. So, for example, one of the requirements you typically see with an open source license is like if you're dealing with code, you actually have to mention the code, that license in the code, right? And so one of the things we've done, the SPDX allows you to reference in a very abbreviated fashion the license that you're using without spending 17 lines on it. So if you have that kind of obligation, you can use SPDX perhaps to satisfy it, assuming that the license permits it. But if you're looking at somebody else's code which is being contributed, you're going to be looking for that same kind of information, try and figure out what licenses are coming into your project. So I'm going to move on. One of the things that all of us in here use GitHub probably, right? Everybody uses GitHub. GitHub, because there's so much government activity, there is actually a special terms. They have terms of service like everybody does. And GitHub is convenient, makes it convenient for us feds because they have Fed-oriented terms of service, which means you don't have to negotiate terms of service, which is, I'll just say, in our practice is a nightmare, trying to negotiate government acceptable terms of services from little, garage software companies that your scientists all want to use their stuff. Anyway, GitHub is in there. And then some government has its own public-facing repositories. There's govcode.org, but more recently there's code.gov, flowing from a memo back in, what was that, 1621, in 2016 on open source software use. How many of you are familiar with OMB Memorandums 1621? No, just Bob and I. So that we spent, I'm not going to talk about it. I don't want to, it's too painful, but it's a yes, ma'am. Yeah.
So generally about 90% of researchers are using GitHub. That's where, and I represent a publisher. Mm-hmm. So when we want the researchers to cite the software that's being used, commonly there's a variety of ways to do that. So here I'm gonna give you the entanglement. So You can pull it out of GitHub. We don't prefer that. That's not a persistent location. Publishers like persistence. So please use the Zenodo connection for a particular release. Get yourself a persistent identifier there, a digital object identifier. So now we made a copy. It's in GitHub. It's now in Zenodo. And additionally, there's an entity called Software Heritage, which is scraping a variety of software collaboration development locations like GitHub. They have a copy too. So now it's in 3 places without a lot of work. So license-wise, the author says, the software author says, you know, it should be in GitHub where the license is identified. Can you take this from here and help me understand what the licensing is? And did we break rules? Or did we support something? Or these copies, this is common, really common. Is this something we can stamp a license on and say, we're good to go, and here, researcher, don't worry, we've got you? Or is it really a quagmire?
Wow.
Okay, great.
So what was it you said to me when we met? What my answer was going to be? It depends. So you've obviously had a good working relationships with lawyers for a long time, but it really does. So, you know, the answer to that question, if there is some kind of prescription in the original underlying open source license against reproduction in some library, then you'd have a problem. It's unlikely, I'll just say, you know, sort of taking with a general understanding of the nature of most open source licenses, open source software licenses, it's unlikely that what you've just described is going to cause a problem. Right? Does GitHub? No, I don't know. GitHub is like this thing. I don't know if anybody's more familiar with GitHub than I.
Hold on. Sorry.
What Shelley's describing is most one-off. It's not software. It might just be a piece of script or code. It doesn't necessarily have to be intended for reuse. And they might use GitHub just collaboratively. And when they go to publish, they'll go through this chain, but they haven't thought about licensing their software at all. And so that's the piece. It may not have anything by the time it gets to you with a Zenodo DOI. Am I understanding that correctly?
Well, it could be a problem. I mean, depending on what you decide you want to do with it later on, right? Are we talking about a government employee work product?
It could be.
It could be.
It could be an
just
international team.
Yeah, it could be an international team. So
It
if
could be somebody from China.
Okay, that's helpful. But I mean, I think if you are voluntarily offering up script to GitHub for everybody to look at, I think you are potentially putting assuming that you haven't made a conscious decision about a license, right? Oh, so it's not a federal employee. Okay.
Yeah, this would be not federal circumstance. So,
okay.
so I would like to, you know, this is exactly the kind of discussion that I think that, you know, the main takeaway I see here is that the researchers who are, and the scientists and the data software engineers need to be considering these licenses in their project efforts and working with their organization, their institutional lawyers, to make sure that they're covering what they need to cover and as you said earlier, the needs of the organization and the project, what it is you're trying to accomplish, because the rules are going to be different for university versus government versus whatever. Yeah.
And a lot of these folks they're not, nobody is there to tell them that they should worry about this until they get to a publisher. And then there's no way to back, right? So
Good.
So they may or may not have the resources to do what you're asking.
Well, that's why we're starting this discussion at ESIP and trying to move it out so that it begins a dialogue in the wider community. Because you're right, there are going to be downstream implications for all of this.
The question that Shelley's asking is it a problem if academics are referencing code, getting a DOI for a piece of code that goes into a publication, but it may be copyrighted but not licensed? What are the downstream implications of that?
Yeah, the potential downstream problem is copyright infringement, right? And that's I had a slide earlier that says, well, what about the stuff that's out there sort of feral that doesn't have any license attached to it? You don't know. And what you've just described here is it's some copyrightable subject matter. Somebody throws it up there. It's not annotated. You don't know. So you're taking a risk in using it that somebody will later assert that they have a copyright because they haven't consciously given up their copyright by putting it up there, right? You don't do that. So it's the unknown versus the known in that context. So yes.
Not that you would answer this today.
Okay.
But to Don's point that this is the beginning of a conversation. So commonly in academia, we've got teams that are international. So now not only do I have US law, but I have European Commission law, EU law, Australian law, Chinese law, and I need what, I have an author who says to me, I'm not going to give you access to this code for this research I'm trying to publish because I don't know if I can or not. And I don't know what to say to them. Like I run away quickly. Like that's a really horrible question to try to answer. And so
what you can say is under the International Copyright Convention of 1863, you can give it to them. See if that works.
What was the last thing you said?
There is an International Copyright Convention. It does go back into the 19th century. And all of the signatory countries agree to abide by certain fundamental copyright principles. So it's actually not as difficult as it sounds coming from your investigator. It's just a reflection of the fact that they're unfamiliar with the.
So once I create an international team, I go there.
Yeah, well, if your international team resides in countries that are convention members, and almost all of the industrialized, but lots and lots of countries, then that convention is going to govern the laws in all the respective countries have to be consistent with it, and what the consequence of that is it's less likely than not that there won't be a problem, that they are in a position to do it.
You're helpful.
So that's just sort of it.
But we do need to move on.
We need to move on. So let me ask this. So I was going to talk about rights and data. And so how many of you are actually involved in contracting? One person, maybe 1.5 people. So I got a lot of slides on rights and data here, but maybe we'll zip through them really quickly. And if anybody wants to talk about rights and data, oh, okay, I've been given permission to zip. So the key here is we have under the FAR, which governs contracts. If you have a contract, the FAR governs it, and you have basically, there are more than 3, but there are 3 fundamental clauses that govern data and copyrightable subject matter, including software, under the FAR. They are the general rights and data clause, which is 52.227-14. We call it the 14 clause. Then there's the special works clause, the 17 clause, and then there's a special one for SBIR awardees, small businesses. Yes. A question already. So a contract, if a federal agency needs to acquire goods or services for the benefit of the agency, then grant is not for the benefit of the agency. So grants, contracts, cooperative agreements, each is a different form. Grants and cooperative agreements are federal assistance awards to help the awardee do something for the benefit of the public. A contract is money given out for the awardee to do something for the benefit of the agency. Right? So I need goods or services, the agency, I let a contract, and so these apply to that. you have to look under your grants provisions. And the interesting thing about what, your questions that you were raising there's a number of initiatives going on right now in the administration governing rights and data flowing from federal funding, including grants and contracts, and how they need to be treated. And so that's in flux right now, is the way I would put it. And I don't know, are any of you on, there's some like NSTC subcommittees and stuff working on that? And yeah, so anyway, it's all going on. I'm not going to talk about it because it's too much is going on. Do you have a question back there? Yeah.
Earth science rights and data provisions that are asserted in all grants and contracts?
Yeah, I had a slide on that, but we skipped over it. Yeah, so yes, I am. So they have their own provisions.
So that is that a flow down in most cases from these contract provisions, or that's a separately designed?
I'm going to say it separately. So NASA under the Space Act has its own authorities to do stuff that the rest of us agencies don't have. And so that's one of the things that they can do, and they do under the Space Act that is sort of, I'm going to say it's NASA unique. So you got the Space Act, you got the Atomic Energy Act. Those agencies under those acts have special authorities that the rest of us don't. But that NASA thing, I mean, although it's they know what they're doing, that's a vanity provision, right? That's special just for us. So that's one of the things I was warning against. But don't tell anybody. Anybody here from NASA? I didn't say that. If there's anybody, okay, I didn't say that. Didn't say that. It's perfectly good. So they know what they're doing. So just going back now to rights and data. So a couple of principles. I'm just going to talk about I'm not going to talk about the SBR, but let's just talk about rights and data. So what it allows contractors to do is to say, okay, I generate something in the course of this contract, which is copyrightable, and I can assert copyright in it without anybody's permission, a contracting officer being God in the context of a contract. I don't need the contracting officer's permission to assert my copyright in this stuff which the government underwrote in scientific and technical articles that contain data first produced in the performance of the contract, and that is published in academic, technical, or professional journals. Okay, so that's an important thing to keep in mind. So that copyright there, if you're doing work under a contract and you're going to publish it, you get to assert copyright without prior approval automatically. And then that also allows you to assign copyright if you're working with a publishing house, which requires you to assign copyright in order for them to publish in their journal. At that point of assignment, then the government gets some rights. They spring out at that point when the articles get created and the government gets a use license. So let's see. And all other data, if it's not going to end up in an article, a journal article, then you have to get permission from the contracting officer to assert copyright in that. And the reason for that is that the contracting officer might say, well, wait a minute, no, these data are ours. You're not going to be able to assert copyright them that belong to the government. And that's going to be a function of the way the contract has been written. So if the contractor doesn't assert a claim to copyright, then the government has unlimited rights in all data first produced in the performance of the contract and all data delivered under the contract. And here are the government's unlimited rights: to use, disclose, reproduce, prepare derivative works, distribute copies to the public, perform and display publicly in any manner for any purpose, and to have or permit others to do so. That's unlimited rights. And those are essentially, that is a recitation of what the rights are under the copyright statute. So that's pretty broad, that government unlimited rights. But when copyright is asserted, the government gets limited rights. And the limitation has to do with the purpose. And so under the limited government use rights, the government can do stuff, pretty much the same kind of stuff, but may do it only for the government or government purposes, not for any purposes, just for the government's purposes. So it's a much more limited right. So that's something to keep in mind there. So there's the government purpose license. That's what I just said. Excellent. So special works. This I've mentioned is important because remember at the beginning when I was saying that we agencies can accept copyright assignments from those who are entitled to it and thereby become copyright owners? This is the provision, the 17th clause is the provision that allows us to do that. The special works provision says for these particular purposes, whatever you generate, data or copyrightable stuff or software that you generate, you're going to assign it to the government. And this is the provision, the 17 clause is the provision that allows us to do that. So I'm not going to talk. Does anybody, if anybody wants to talk about the SBIR program, just let me know. And that's all I have. And I look forward to, there's questions already, but we need to get on here to Bob's presentation.
We'll see how it goes. I know who you are.
Hi there, I'm Tyler. I work for NOAA. I think that you've already answered this question, but so we have the new legislation that says that that government data needs to be open by default. And we keep getting asked by people who want to use our data, our open data, that we provide to the public free of charge. They want to know what the license is for that data. They would like us to assign a license in a machine readable format so that they know what does open data mean. So I assume you've thought about this question, and what should that default license be for anything that we don't have a reason to restrict it? It's open to the public for them to use, but what would the license be, the formal license be that reflects that open by default?
Well, so I mean, what I would say if I were pressed on this is that we are looking forward to guidance from OMB on that kind of thing, right? Because that's the unfortunate truth. And so when OMB figures out what they want to say, we'll probably all regret it, because there won't be a one-size-fits-all solution. I would personally, if you're generating data that you think is going to be important to a particular community, then we go back to the beginning slides and say, well, what is it you're trying to accomplish, and what license, model would allow you to accomplish that, and try and make an informed decision about the license that you're using. And we didn't even talk today about Creative Commons licenses, right? And those are out there, and we can talk about those after Bob's presentation, but there's another, so we get Creative Commons questions all the time because it's so easy, but it's not always appropriate. So
I don't work for the government. I work for an FFRDC, and my impression of licensing concerns by the operating institution is more limiting of liability than it is anything else. If you put something in the public domain, do you still have liability?
Oh, yeah. Do you? You mean as a federal agency? No,
as a private entity or as an FFRDC, if you take a piece of software and assert no copyright and explicitly put it in the public domain, do you still retain liability?
Yeah, you could get in a lot of trouble if somebody, hurts themselves, or software for automated vehicles drives somebody off a cliff and stuff like that.
Okay.
So what you'll see, and I think Bob will have in his presentation some examples of the kinds of things that NIST does to address that kind of liability question, attribution and disclaimer basically of liability. But at the bottom, for a federal agency, the Federal Tort Claims Act is always there for us.
Right, but for a private entity, it is not advisable to put something in the public domain.
Well, no, private entities can put stuff into the public domain, and they need to do that, with the appropriate disclaimers, right? If they're going to do that, try to shield themselves from unlimited liability, right? So, at your own risk, no warranties, kinds of things, and you'll see that. Another question?
No, I think that's it.
Oh,
thank you so much.
All righty, thank you all.
Situated here. Like I said, I thought there would be a little bit of discussion about some of this, so I'm glad I was right. This has been a really interesting session. Okay, let's see here. There you go.
Thank you. All right. Well, I won't be nearly so long or controversial as Henry, I hope. I was telling Don before the session that Henry and I have known each other for like 30 years now.
We're not old enough.
And Henry started at NIST a few years before I did. And the first week I was there, Henry came into my office to welcome me to the agency. And everybody said, what kind of trouble is Bob in already? That he's got the chief counsel in his office. So. Right. So I'm going to tell you a little bit about what we actually do around data distribution and software distribution at NIST. And it drives back to this so-called data pyramid. So at the bottom of the pyramid, we have working data. Working data are data that come off of an instrument or out of a computer simulation directly without any sort of analysis done on them. Derived data may have some processing, some calibration done on them, but those data products we do not require to be made publicly available because there'd be a burden in trying to archive and catalog all of this information. A lot of data is taken from an instrument just in exploratory mode. How is the instrument working today? It has no scientific value. But once data become publishable or published, we do require that they are put into our public data repository. Metadata records about those data are aggregated by us and also then forwarded into the data.gov metadata repository. So it's discoverable both through a front end that we have at NIST and also through the data.gov repository. Standard reference data are a special class of data at NIST. These are data that have been very carefully vetted for quality by experts in various domains on the staff at NIST. SRD was defined formally in 1968 by the SRD Act in Congress, and this authorized NIST to create standard reference data and to copyright those data. So this is an exception to the general rule that Henry was talking about, that generally works by US government employees are not copyrighted in the United States, but SRD are copyrighted. And we also are authorized to do cost recovery for standard reference data in terms of what does it cost us to produce the data, to archive the data, to distribute the data, and to maintain the data over the course of time. So standard reference data means this: quantitative information related to a measurable physical or chemical property, et cetera, et cetera. Standard reference data may be made available and sold with the prices to reflect the cost of the production and the distribution thereof. And the Secretary of the Department of Commerce may secure copyright and renewal for these data. We actually amended the SRD Act of 1968. It went into law in early last year to include measurable characteristics of a physical artifact, engineering properties or performance characteristics of the system, or one or more digital data objects. And that's kind of legal language to talk about software, because a number of our SRD products are a combination of data and software analytics that run on top of those data. And it wasn't clear in the original SRD Act whether those types of standard reference data would be protected. So they are now. And actually, I co-wrote this language, so I have written something into the US law. So how about that? So what does critical evaluation mean? It means that subject matter experts at NIST either produce, collate, review, and test for validity and consistency the data that become SRD. There are documented measurement procedures. Uncertainty characterization is really important. You can't just say the number is 2.3. You have to say 2.3 plus or minus some error estimate. And the data must be presented in SI units, this International System of Units, and traceable to SI standards. So that's a pretty high burden. We have currently about 100 SRD products in our portfolio. We charge money for only about 15 of them. Most of them we give away, but we do charge money for about 15 of them. The most famous of these is the mass spec reference database, which is basically purchased by instrument vendors who embed the database in their instrumentation. And so if you're running a mass spec test on a sample, it will automatically be checked against the NIST reference library. So why do we do this? Why do we claim copyright? SRD are commonly used in industrial applications for design and safety. If you want to know how much steel to put into the foundation of a skyscraper, or how thick to make pipes to carry liquefied natural gas or whatever, we have the data that industry uses to make those determinations. So one, it has to be right, or as right as we can say, and we can't permit others to modify it and claim that it is still the same data. There are serious safety considerations here. And Henry's watching me carefully, so I know he's going to correct me if I make any mistakes. But one example of one of our free SRD products is the NIST Chemistry Webbook. This is a website. That's how it's presented to the community. It compiles all sorts of properties of chemicals, chemical processes, and so forth. Thermochemical, spectroscopic data, thermophysical data, other types of data. It presents these data through web pages, and it is the second most popular website that we operate at NIST, the first being our time service. Everybody wants to know what time it is. But after that, the Chemistry Webbook is used by students, by educators, by industry internationally. In the licensing area, our non-standard reference data, that is our research data and NIST developed research software, are not copyrighted, but they're distributed under a fair use license that is specific to NIST. I imagine Henry had something to do with writing the language for this, or does it even predate you?
No, it's Mark Madison of my office that works on those, and we provide that kind of language.
So the language in gory detail is available at this website, nist.gov/open. I just made a copy of the terms and conditions here, but this is getting to the question before, in terms of this is how we relieve ourselves of liabilities for potential misuse or misapplication either of the data or the software that originates with our research staff. So I'm not going to read this for you, but basically it's, NIST shall not be liable, and you hereby release NIST from liability. So those are the important aspects of this. For the data, research data that we distribute, it is allowed to be improved, modified, and derivative works may be created. We do ask people to refer back to the origin of the data with the NIST research scientist. For software, again, it's a very similar kind of language. The software is provided as is without warranty of any kind, expressed, implied, or statutory, etc. So we're covering ourselves. We want to make our research products as widely available as possible, but we want to make sure that people use this data and the software, basically at their own risk. Distributions of NIST software should also include copyright and licensing statements per all of the advice that Henry has just given you, bundled with the code. And if you have questions, you call Henry or his staff. I just wanted to show you what our public data repository looks like. My group has developed this over the past couple of years. Basically, all of our public-facing data products are discoverable through this interface and are downloadable from the public data repository, which is hosted in the Amazon cloud. The data are available freely, and we do not have any access restrictions on these public research data. If you go to data.nist.gov, you can run the queries and see for yourself. And that's it for me. I told you it was going to be much shorter.
Okay, so let's have some questions here.
Sure, they're going to be all for
And we have about 20 minutes or so for discussion and other questions. So if you've been thinking you wanted to ask something, I'll get to you in a second time. Please have that ready to go, and we've got a little time for that now. Thank you.
Hi, Tyler.
Hi. So for your open data, license text that you had up there, yes, the next one, please. So you may modify, create, and create derivative works, and so it says, please acknowledge NIST as the source. So you're not requiring attribution, but you're asking please to identify NIST as the source if you
Yeah,
use the data. Is that true?
That's what it says. I copied it right off the website. So.
How strong is that, please?
Yeah.
It's an interesting question. So it goes back to the fact that we, for these data, we don't have any copyright in the data, right? So what do we do if you use it without attribution? We got nothing. And so basically our attribution request is a pretty please. And it's interesting because those of you, and this gets involved in a lot of big data projects, a lot of standards related projects where we're contributing to what becomes a standard, a national or international standard, and all the standards developers want assignments. They want permission to use our content and well, we got nothing to give them. So we give them these disclaimer statements to them that says, well, you know, we don't have copyright in this, so you're welcome to it. And to the extent that you have a collective work, well, you have a copyright in your collective work, but this little part of it is it's not ours. And I mean, it's not enforceable. And when we were talking with a couple of 3 years ago with the 18F people, if anybody interacted with the 18F folks in GSA, they're sort of responsible for trying to do, creative licensing. They were all over this. We keep asking them, what would be the basis upon which we would actually assert an enforceable right to have attribution, and they had no answer for us. And in fact, there's no answer. So as long as we don't have a copyright, we don't have the underlying right, we don't have the ability to do anything other than say pretty please. I'll just share with you all, there is an initiative right now that would allow, if has a legislative initiative that's in process, and whether it'll go anywhere, I know not, that would create an exception, a broader exception under the copyright statute for computer programs, which is a copyright term, but basically for software that is generated by federal laboratories. And this is part of the reason, is we have a right then. The theme is, right, you have the right, you can do whatever you want with the right. Once you have it, you can disclaim it, right? You don't have to enforce it. But if you don't have it to start with, you got nothing to work with. So the reason for that copyright initiative is that if you imagine yourself in your garage wanting to take a product and spend the next 4 years of your life trying to turn it into a commercially useful and sellable product, you need to have something that allows you to do that without then having the work taken away from you and stolen by all your competitors. So in that small sliver of commercialization opportunity, it would be nice to be able to say, hey, here's a software product that was generated by the government. Somebody take this, please, and put another $300,000 into it and make it a sellable product. And you need an intellectual property right to do that, and the copyright would be that. This wouldn't change the fact that NIST puts 80% of its stuff up on GitHub. We'll still do that, but then you'd also have this opportunity to promote commercialization. So that's where that's coming from. Yes. Whoops, sorry.
As a researcher, I want credit. If you're going to use my data, I want credit. If you're going to use my software, I want credit. So let's head down data. So I know enough about Creative Commons that I assign CC BY 4.0. I want attribution. So it's open, take it, but you give me attribution. So now, as a person recommending data management best practices to researchers, I tell them, when you go to use somebody's data, you make sure you know what that license is. You be really clear on that, and then you have to follow those guidelines. And if there is no license, you have to go talk to whoever's got this, because you can't just go use that data if you have no idea the license. The government is messing me up. I don't know, there's nothing out there to put my hands on. So I could use some guidance there. Okay. So now I say to repositories, make sure you ask these researchers who are putting their data in your repositories what their licensing is, and get that documented on your webpage in a machine readable way so it's super clear. By the way, recommending attribution is a great idea. So let's take a particular repository that happens to default to CC BY 4.0. Okay, that's on the website. See, I almost have a question. I'm almost there. So the researcher loves this particular repository, puts the data in. That's the license that's recommended and assigned to the data. It happens to be an NSF-funded repository. Hang in there. There's a requirement to make sure that that data is archived long-term. So they have a 2-year funding cycle. They can't be the long-term archive. They make an agreement with NOAA. So NOAA has NCEI. That's their repository long-term, right? We're fans, right? We love it. The data goes there, but they can't take the CC 4.0 license. Shit. Ooh, oops. Darn. And NOAA has to comply with the National Archives. They're like no on this. Like we're not taking that license at all. We are in such a quandary right now. We don't know what to do about this. We literally can't move data to NOAA because they won't take this license. But yeah, that's good enough. That is my question. What do we do?
Wait for OMB guidance on it. No. Yeah, I mean, so one of the
Glaciers will melt.
that
Literally.
agencies could do, if you were to think about it, right? You're drafting up a grant, a notice of a funding opportunity. And one of the things you can consider trying is to recite in your notice of funding opportunity. In fact, agencies are going to be obligated to do this. What is your data management plan? Right? We're all being driven to come up with data management plans. And so you could imagine going in a direction that says in your funding opportunity up front, right at the very front, that says, here's how we're going to manage your data. We're going to, tell us what, how you're going to license it to us, if you're going to make it available, and be aware that we're going to do this with it, which includes giving it to NASA, right, for their thing. And so you tell all the applicant and the consequence of that, right, which is, I guess you could say, NASA doesn't accept Creative Commons version 4.0. So if you want to use,
You could license it under 4.0 first repository, which will take that.
right. So all I'm trying to get at is if you imagine yourself doing awards going forward and telling all the potential awardees, well, how it's going to work, then they can take it or leave it. And that's probably going to be the best that we can do. And
just to clarify, I'm pretty sure, and Tom, maybe you can fact check me while I'm making this response, please. I think CC by 4 was actually okay. It's CC by 3 that can cause problems for us, for NCEI, because of the limitations within that. So that's where it's these nuances. Is it 4 that we could? Okay. I know one of them was we couldn't, and one was okay sometimes. And yeah, and this is where that was why we're having this session, actually, was discussions like this, because we're trying to find the right answer to support the data provider communities as well, so that we can, when we're asked, what should we do? And we're hoping that when OMB comes out with their guidance under the Data Act of 2019 or whatever exactly it's called, that there will be some additional guidance for us in that respect, so that we can give better advice. But we're also you can do I encourage our citizens of the United States to participate in their government directly whenever they can. How's that? So, okay, here you go.
If my only intent is to disclaim liability, is there a license you would recommend, or simply insert a disclaimer of liability into the entity?
So if you're a private sector entity, right? So one of the reasons that that private sector entities like to do bilateral agreements with lots of provisions is because you create this enforcement or enforceable construct, so that if you have a disclaimer of warranty in your agreement with another party, you can actually go to court and have the courts determine the consequence of that, which should be, yeah, you disclaimed it, the other party agreed to it, therefore you don't have any liability in this particular instance. And those are all fact-based determinations. In the absence of that, right, where you don't have that bilateral agreement and you just make a flat-out statement like NIST does, or anybody does, and let's say it is from, federal government perspective. The federal agency says, use this at your own risk. These data we're providing to them, use them at your own risk. Well, we say that, but as I mentioned in passing, the Federal Tort Claims Act sits out there anyway, and anybody can sue the government for a tort no matter what we say. So it's, it's precatory. We hope this will work. We're saying it. We're trying to put you on notice. Our lawyers will stand up in front of the judge and say, look what we said. But the ultimate question of whether or not the government can get out of liability for a tort will be figured out by the judge, and won't matter what we say. Whereas if in between two parties under contract, you're in a much better situation. I don't know if that helps or not, but that's a sad and painful truth.
Okay, going over here.
I've been following this as quite close as Don has, but I think what the issue is, and I think it's important to state, is just because I have a right to distribute to anyone I want, doesn't mean that the person I distributed it to has a right to then, also distribute it to anything they want. And I think that's really where the crux of the matter is. The people can give it to us, but that doesn't necessarily mean that we can freely distribute it also freely distribute it.
Right. I think that's an important concept. Earlier, right? Different licenses, different open source license models address that concept differently. And some of the, the less restrictive or more open models are exactly the opposite. They said, give it to me. I got no control over it. You're, under this license, you can do whatever you want with it. And there are other open source licenses that actually say basically what you said, which is I'm giving it to you, but I'm not necessarily allowing you to give it to anybody else. And so that's one of the reasons you need to look at your open source license before you get going, because if you intend for the recipient to be able to give it away again, you may need to make sure that you use a license which permits that, as opposed to a license which doesn't permit that. And going to sort of your question, if you're getting stuff from third parties contributed to your community, which have licenses that vary in the ability to give it to the third party, you're going to be tripping all over it. So you need to take that into consideration, and in creating that community, say, here's what we'll accept and here's what we won't accept based on what your mission is for that particular project. So, I mean, NIST has, we've got software that's been out there that could have been, if we had the ability, it could have been turned into useful products that people come and use all the time. We have some software correction software, which is really, really powerful. We've created a community around that, and we control the software. People can contribute, but it's, it's, what's the right word that I'm looking for? It's, nobody gets to do anything unless somebody from NIST says it's okay or not. And so, we have stuff like that where we actually control what goes on, and we know exactly what changes are made, and we don't permit any changes that we don't want everybody's trying to contribute to. And we have other programs where we just throw it out there and we don't care. You do whatever you want with it. And it depends on the mission of the group. The particular group, and they presumably make those kinds of decisions.
Okay, and to go back, just to go back to your question, actually, and the CC by 4, Tom was right. That was determined by the legal counsel we talked to be a problem for us, because it has it does not allow for sub-licensing. So depending on as Tom framed it, it's like someone can give something to NCEI, and if NCEI is considered to be part of whatever the organization applying the license was, then we can redistribute it. But if we are receiving it from the license creator, that particular license doesn't give us permission to redistribute it. That was where we had a problem with the CC by 4. And because we can't, it has to stop with us, and we can't redistribute it. We can't, we're not through that license, we weren't allowed to, that's not a good one. That's not a good one for us to be able to be the long-term repository and redistribute those data. CC by 1, no sublicense restriction, that's what we were told. And so that was okay. That was, I'm looking here at my notes, CC by 1, CC 01.0 universal, doesn't raise any concerns, allows for public redistribution with, and please attribute. And so, you know, this is where, you know, it's digging down, you know, not lawyers in trying to dig down into license language and say, this sounds like it's going to cause us a problem, we need help. That was where we started in this discussion. And now we're encouraging our data contributor communities, the publishing community, all of us to start being more aware that down in these different licenses, there's all kinds of stuff embedded in there that, you know, how many of us, you know, every time you update your iPhone, you read all of that language and then you say, I accept. We all do, right? Yeah, okay, I see a lot of hands in the air. So it's like, we're accustomed to sort of like glossing over that. And so it's important for us, at least for this purpose, to be sure we're aware of what we're saying we think we want to have happen before we just say, yeah, here, use this license because we've always used that license or whatever. And that kind of also goes back to what Danny was saying, I think. It's going to take a different, it's going to take an education and outreach effort among our scientist communities to say, you really need to start thinking about these things because we're no longer in the era of, you know, I'm going out and doing my thing and it sits on my desk and then when I retire, I turn it over to someone. Those days are way long gone, and we need to be thinking of the interconnected world that we take so much for granted and still don't necessarily address. That's my view. So I'm going to go back to Daniel. There you go.
Thanks, Don. So to follow on what you said in the interconnected world that we are living in now, I think that it's important to consider or bring to the table also the funders and the publishers here, because as a repository, you can get into a scenario, or we do get into scenarios where we are in the scenario where the publishers expect a certain rigidity in the licensing in terms of explicitly articulating attribution to the originator of the data. And then as a repository, you try and meet that requirement so that the author isn't impinged. The data provider can publish his scholarly work, and then you find out that the downstream effect of this is that it can't be archived. So I feel like the publishers need to be as equally aware as the author, and then the funders need to understand this is an issue as well. And so I think it's maybe it's a perfect Coptis, publisher, funder, researcher coalition kind of thing. But I think everybody needs to be in so that everybody's on the same page. You know, at the end of the day, I think what we're all trying to ensure is that the right thing gets done, right? I mean, somebody created this piece, and whether it's licensed or just copyrighted or it's unique, or they didn't create it, but they documented it, right? So it's unique, and you can't go back and find it, and just give the credit that's due. And I think that's what we're all aiming for, us much more so than liability of, or toward, or any kind of damages, but really just the attribution piece is what we're getting at here for a repository.
Okay, and with that, thank you. I want to thank everyone here again for coming today. I think this has been a really interesting session. I really would like to thank our speakers, Henry and Bob, for fascinating presentations and sort of a mini masterclass in license and software issues. So, and I hope that if in your feedback to ESIP, if you would like to see other sessions that build on this one, please let the folks at ESIP know that. And I'm happy to keep in this discussion as well. So thank you all for being here. And yes, go ahead.
To add one other thing, and the American Intellectual Property Law Association has a subcommittee on open source and standards, and every fall in October, NIST and that subcommittee do a partnering and standards program. It's usually at the Department of Commerce for feds, and we have people from that committee who are private sector, most of them are private sector attorneys, come and talk to us about topics, and very frequently the topic is open source. And there are people on that committee who are gods of open source. I mean, they know this inside out and backwards. So if any of you feds are interested, let me or Don or anybody know, and we can put you on our little mailing list. And usually we start to put something out around September, a save the date. But like it's usually like the second, third week in October, and it's a half day or a full day program downtown, and it's like it's closed press, and you can talk about whatever you want to, and you don't have to worry about anything. So they've been some very good programs, and it's free. So just wanted to let you know that.
Great, thank you for that, Henry. Thank you all very much for coming. Thank you folks for the online. We're going to close the session now.